Before we go to in-depth discussion of the corporate veil and what are the main cases and principles that you need to know about this concept, I would like to remind you about the problem question style that you need to follow in order to be successful. Please consider that knowing the law, the cases, and the principles is very important, but you won't be able to succeed if you only do that part. Very important part of being a successful law student is knowing how to answer problem questions, especially for company law, because you will be getting a lot of problem questions in your exam. For problem question style, you don't need an introduction like you do for an essay question. You can dive straight to the issues, identify all the legal issues that arises on the facts of the case, and relevant laws, very important. This is where you show your legal knowledge, that you're able to not only identify the legal issues, but also discuss the relevant laws that applies to the facts of the case. Application and analysis part is the most challenging one, and you need to practice a lot before you go to the exam to be able to successfully attempt this part of the question. In this part, you need to apply the law to the facts of the case and provide the correct analysis. How do you practice? Well, you can use the past exam papers from your university. It's the best way to practice because the exam questions that you will get this year will be very similar, most probably will be very similar to the ones from last year and the year before. And if you're very well prepared to answer past exam papers, that will prepare you to answer this exam as well that you will be getting. Finally, the conclusion part is where you sum up your analysis and you conclude what would be the most likely outcome of the legal issues that you have just discussed and conclude if this case would succeed. Essay question style is different. And here we need an introduction. Introduction can be around 10% of the essay. If the word limit is 2,000 words, the introduction can be around 200 words, but make sure that you don't write too long the introduction, because introduction is supposed to be only a brief summary of the case, of the law at hand. So for example, if you have an essay question about corporate veil, which is very common, you may get an essay question on corporate veil, and you should be prepared for that. And in that case, you can have like a 200 words introduction that will introduce the law on corporate veil, discuss the relevant, most important cases such as Salomon case, Prestwitz betrothal, and introduce the issue at hand. Most of the students understand essay questions like different way. So if it's about corporate veil, many students write everything they know about corporate veil, but that's not the right way to approach essay questions. You should answer the question asked, and it's very easy to get off track. So make sure that you read the question that has been asked to you multiple times when you write the essay question to make sure that you are on track and you're answering the question asked. Also, very important point is that you make arguments and refer back to the question asked. Do not make your essay explanatory. Most of the students do that. It's one of the most common mistakes that lowers your grade. If you just explain the relevant law, that is not going to get a high grade. On the contrary, you may even not be able to pass if you just explain the law. So make sure that you make arguments, refer back to the question, and you analyze the law that has been discussed, and you answer the question asked by making convincing arguments. Now we're going to talk about corporate personality, because this is a very common question on company law exams, and very often it comes up as an essay question. Let's talk about Salomon case, because this is the cornerstone of this topic, and you need to be familiar with the facts as well as the principle that came out of this case. Salomon and his family members were the sole owners of the company. Company went into liquidation, and the issue at hand was if the liquidator could lift the corporate veil and use the personal assets of Salomon to pay the debts of the company. There were various legal ways suggested that this could happen. First one was agency. It was in the first instance judgment, that Salomon was argued to be an agent of the company so that he was responsible for all the debts incurred in the course of the agency for him. However, appeal in the House of Lords rejected this argument, and there was nothing in the Companies Act 1862 to show that Mr. Salomon had done something that was prohibited. Lord Magnaton even noted that it was the policy of the Companies Act to enable sole traders to incorporate their businesses. So beforehand, Mr. Salomon was a sole trader, and then he incorporated his business as a company. And the judges here highlighted the fact that that's nothing wrong with that. It's actually the main idea of the company, that you can avoid personal liability if you have a company, because the company is like a legal shield that can protect you from assuming any personal liability for things that is done by the company. So the idea of corporate personality, separate corporate personality and corporate veil was first discussed in this case of Salomon, which meant that companies both association of its members and separate from its members. The liability that the company has cannot be assumed by the members, but there are exceptions that we will discuss later. The company is therefore at law a different person altogether from the subscribers to the memorandum. What is the memorandum? The Articles of Association. This is like a constitution of the company, and all the shareholders subscribe to it. And this means, this principle basically means that company is a separate person from its shareholders. Shareholders are just the subscribers of the company, but they are not personally liable. Therefore, after the incorporation, the business is precisely the same as it was before, and the same persons or managers in the same hands receive the profits. The company is not in law the agent of the subscribers or trustee for them. In this case, as I mentioned before, Mr. Salomon was a sole trader before, but then he incorporated the company. But nothing changed. It was the same people were doing the same business. But despite of this, the court still said that they were not personally liable. Other cases also reiterated this Salomon principle, such as Lee versus F. Farming. The company here employed Mr. Lee, who owned 2,999 shares of 3,000, and he was company's only director and had been appointed governing director for life. Mr. Life was killed in the course of his work for the company. An issue was if Mr. Lee was an employer under a contract of service for the company, and the company's insurers argued that there was no contract of service and no claim could be made as to the compensation. The judgment, Lord Morris argued that it's a logical consequence of the decision of Salomon and the concept of separate corporate personality that one person may function in dual capacities. There is no reason, therefore, to deny the possibility of a contractual relationship being created as between the deceased and the company. In this case, it was recognized that a director can have a contract with the company. Despite of the fact that he was almost the sole owner and the only director of the company, he could still have a contract with the company. Now we need to discuss the corporate veil principle and the situations in which corporate veil can be lifted. It is very important that you are familiar with this concept, with these legal principles and cases, because there is a high chance that you get essay question on this topic if you have an exam in company law. For many years, there has been discussion about whether a court can ignore the separate legal personality and can treat the company's property, rights, and obligations as belonging to a person who owns and controls the company. This has been called piercing the corporate veil. Here we will be talking about activities that are unconscionable. So what happens when the company is involved in fraud or in similar kind of activities that suggests that the court should look behind the corporate veil and see who are the managers of the company to deter this kind of activities. What problem does separate corporate personality give rise to? This is a big privilege that can be abused by unscrupulous business people or by people on the advice of their lawyers. And there are ways in which the corporate veil can be lifted to deter this kind of activities. Prest versus Petrotto was one of the cases, a key case about this concept, and you need to discuss this case when you're talking about piercing the corporate veil, whether it's an essay question or a problem question. The main judgment was delivered by Lord Sumption, and you need to remember this name. Lord Sumption was the main judge, and Lady Hill. Corporate veil can only be pierced in exceptional circumstances when the defendants are trying to use the veil for fraudulent purposes to conceal or evade liability. So it's otherwise called the concealment or evasion principle by Lord Sumption in the case of Prest versus Petrotto. Basically, he stated that if the court says that there are activities going on in the company that conceals or evades a liability, in that case, the court is allowed to look behind the corporate veil to see who are the people responsible for this and to deter this kind of activities. But Lady Hill stated that piercing the corporate veil should be the last resort if no other legal remedy applies. The case of Prest versus Petrotto, the facts of it are interesting. So it was basically a divorcing couple, and the wife was arguing that the court had to look behind the corporate veil of the company that her ex-husband owned, and so that she could get some of the company's assets as a divorce settlement. What happened is that the husband had put some of his personal belongings in the company's name, but that was not because of the divorce. That was a few years before the divorce. And there was nothing to suggest that the husband was engaging in any fraudulent activities. He hasn't concealed or evaded his liabilities. And he hasn't hidden his assets from the divorce proceedings. The reasoning in Prest is that concealing or evading liability described by Lord Sumption held that piercing the corporate veil can only be used when applying the evasion principle. Lord Sumption, Lord Neuberger, and Clark also noted that the court can pierce the corporate veil only if it is necessary to do so. Before this case, we have various cases suggesting that in many occasions, the courts were looking behind the corporate veil. So this was undermining the whole idea of separate corporate personality and the Solomon case, and it was no longer clear on what basis will the court empower themselves to look behind the corporate veil and see who are the managers of the company. So that is why the judgment of Prest versus Petrotto is so important, because after many years of uncertainty, it has clarified the law in this area. The difficulty is to identify what is relevant wrongdoing. References to a facade or sham beg too many questions to provide a satisfactory answer. The Lord Sumption in his judgment uses this kind of words, and in many cases, it can be hard to see what is a sham structure. It seems that two distinct principles lie behind these pertinent terms, and that much confusion has been caused by failing to distinguish between them. They can conveniently be called the concealment principle and the evasion principle. The concealment principle is legally banal and does not involve passing the corporate veil at all. It is that the interposition of a company or perhaps several companies so as to conceal the identity of the real actors will not deter the courts from identifying them, assuming that their identity is legally relevant. Therefore, if the company's managers are using the corporate structure to conceal their identities in case of fraudulent activities, this will not deter the court to look behind the corporate veil. Paragraph 35 by Lord Sumption in press is also important. I conclude that there is a limited principle of which applies when a person is under an existing legal obligation of liability or subject to an existing legal restriction which he deliberately evades or whose enforcement he deliberately frustrated by interposing a company under his control. The court may then pierce the corporate veil for the purpose and only for the purpose of depriving the company or its controller of the advantage they would otherwise have obtained by the company's separate legal personality. As you can see, he emphasizes on the fact that only in this occasion the court will deprive the person of this privilege that they have by having a separate corporate personality. It will not be used, passing the corporate veil principle will not be used in any occasion. Like Manby and Jay and Ben Hashem, I consider that if it's not necessary to pierce the corporate veil, it's not appropriate to do so, because on that footing, there is no public policy imperative that justifies that course. I therefore disagree with the Court of Appeal in FBTB Capital, who suggested otherwise. For all these reasons, the principle has been recognized far more often than it has been applied. Therefore, you will see the cases before Press versus Petrotto about piercing the corporate veil, where the corporate veil has been pierced in a lot more occasions that Lord Sumption described. And it was the rules on piercing the corporate veil was a lot more relaxed. If you have a problem question about this topic, you need to apply Press versus Petrotto because this is the latest authority on this concept and not the cases before. However, if you have an essay question about this topic, it would be useful to discuss the development of the law in this area and the impact of Press versus Petrotto. How did it change the law in this area, clarified the principles on piercing the corporate veil. The cases of parent holding companies are also about this concept, and it would be useful if you have a look at those cases, like Adams versus Cape Industries. Here, four main arguments were made for making a parent company liable for the conduct of the subsidiary, and the grounds for piercing the corporate veil was argued to be the following: sham relationship, agency, group entity principle. The subsidiaries are all part of the group, thus if the damage is to one entity, it is to all the entity, and justice, equity and fairness argument. So this case was decided in 1990, and the main judgment was delivered by Lord Denning. It represents the laws on separate corporate personality very differently as it was represented in Solomon. And it could be argued that this case rendered questionable the whole idea of separate corporate personality as explained in the case of Solomon, because it recognized the grounds such as agency, a ground for piercing the corporate veil, and group entity principle, that if one subsidiary is liable for something, all the subsidiaries will, or justice, equity, or fairness. So this kind of widened the scope of piercing the corporate veil. Therefore, the intervention from the Supreme Court with the case of Press versus Petrotto was very much needed. Chandler versus Cape PLC 2012 was also a case before Press versus Petrotto. And if you have an essay question about this topic, it would be useful to discuss, to contrast these cases and analyze the argument that has been made and how the law has been evolved from Adam's case to Press versus Petrotto. Also, this case, Thompson versus Renwick Group, important case about this subsidiary companies concept. Here it was argued that the mere fact that a parent company has appointed a director of a subsidiary with responsibility for health and safety is not enough to establish assumption of a duty of care for health and safety of the subsidiary's employees. Therefore, here, as you can see, the group entity argument was no longer applied. It was Press versus Petrotto, and a mere appointment as a director did not make the person responsible for health and safety for another company. Here are all the important cases that I suggest you to read after this session. You will receive the slides and you will be able to look at these cases. And I suggest that you read the facts of the case and the principles in detail. I would like to briefly tell you about how we can help you with your company law studies. At Simple Study, we have simple notes, example answers, tutorial videos, quizzes, flashcards, and all the Simple Study resources you need to be successful in company law and get a high grade. We're a group of top students and graduates. In our team, everyone has achieved high grades, and we're now sharing our experience and knowledge with you to help you have the same success as we did. If our Simple Study materials are not enough, you are more than welcome to have a look at our tutoring services. This is an additional service that we offer. It's a one-to-one personalized support on a Zoom call like this one, where we'll be able to assist you with any particular issue that you may be struggling with. It can be help to prepare for your exam, practice answering problem and essay questions. It's very common that students want to practice answering problem and essay questions before they go to the exam, and you're highly encouraged to get a couple of tutoring sessions before your exam comes. We have already helped thousands of law students to get high grades. 90% of our regular users get a first class, and by regular users we mean that you need to be studying with our content regularly, and you need to at least get a couple of tutoring sessions before your exam comes to practice answering questions at an adequate manner. We would like you to be our next student to get high grades. Please join Simple Study now. Thank you very much for your time. If you have any questions, I'll be glad to answer.